Morning to all. This is Dr. B. Srinivasan, Assistant Professor from Sacred Heart College, Tirupattur. The subject is Income Tax Law and Practice, and the topic is Residential Status. And before that, the objective of the session is to understand the concept of residential status towards individual. I have few questions here. Does income earned by Messi in India is taxable or not? Question number 2. Does income earned by Virat Kohli in Australia for playing ODI is taxable in India or not? We shall see the answers at the end of the session. Residential status. What do you mean by residential status? It is a status that has been determined based on the number of days a person stayed in a particular country. Okay. Why we have to learn about the residential status? Because the total income and tax liability of an assessee is determined based on the residential status of assessee during the previous year. Hence, it is not charged based on the citizenship. Okay, what is the difference between a residential status and a citizenship? A residential status depends on the number of days a person stayed in India. Rather, citizenship is determined based on the place of birth. Will it be changed or not? A residential status will change at each and every year, depends on the person stayed in a particular country. Whereas citizenship is mostly it won't change in every year basis. Okay. A citizen of one country may not be a citizen of another country, whereas a resident of one country can be a resident of another country. Okay. At the end, we could summarize that income tax and the scope of income is decided on the basis of residential status, and it is not decided based on the citizenship. Okay. Then, with regard to residential status, we have three types of status. One is ordinary resident, two not ordinary resident, and point number 3, non-resident. Why we have to learn these type of resident? Because tax is based on the type of residence. Suppose, let me give an example. Suppose a person is non-resident, then any income earned by non-resident in India alone taxable in India. Whereas in case of ordinary resident, any income earned by him in India or foreign, whatever it may be or wherever it may be, it will be taxable in India. He has to pay tax for Indian income as well as foreign income. Whereas with regard to non-resident, he has to pay the tax only for the income earned in India alone. Okay. Then how it will be determined? The type of status. The type of status is determined based on ordinary resident and not ordinary resident that has been posted under Section 6, Subsection 1 of Income Tax Act 1961. So Section 6 deals with residential status and Section 6, Subsection 1 deals with residential status of individual. Why we have to learn about the basic condition and additional condition? Basic condition and additional condition alone determines his status. That means a person will be called as ordinary resident when he satisfies any one of the basic condition and both the additional condition. So there are two basic conditions, out of which one must be satisfied by him, and there will be two additional conditions, both has to be satisfied. Then only he will be treated as ordinary resident. Then suppose a person satisfies any one of the basic condition but fails to satisfy the additional condition, then he will be treated as not ordinary resident. And at last, if an individual fails to satisfy the basic condition itself, then he will be treated as non-resident. He will be treated as non-resident. Okay, here we shall go through the rules with regard to basic condition and additional condition. First, we shall see the basic condition. What is the first basic condition? The condition is an individual must have stayed in India for a minimum period of 182 days during the previous year. Or the second basic condition, he must have stayed in India for a period of 60 days during the previous year and 365 days during 4 years preceding the relevant previous year. Here we shall see that our assessment year is, that is, assessment year means current year. Our current year is 2025-26. So previous year is 2024-25. Okay. If Mr. Ram will be treated as ordinary resident when he satisfies any one of the basic and both the additional conditions. In such case, if Ram stayed in India for a period of minimum of 182 days during the year 24-25. So minimum how many days he must stay? 182 days. Suppose if he doesn't satisfy the first basic condition, what will be happen? He has another choice. Choice number 2, B. That is, he must stay in India for a period of minimum of 60 days during the previous year. That is 24-25. He has to satisfy 60 days. Then, in addition to that, minimum of 365 days must be stayed in India during the 4 years preceding the relevant previous year. What is our previous year? 24-25. What is the preceding 4 years? 2021, 21-22, 22-23, and 24-25, 23-24. Out of these 4 years, he has to stay a period of 365 days. So this is the choice. Usually the choice will be applicable all the person except 3 cases. Case number 1, an Indian citizen, an Indian resident leaving from India for employment purpose. In such a case, he has no choice. He must satisfy the first basic condition itself. Point number 2, an Indian resident goes out of India as an employee in a ship, then he has to satisfy the first basic condition itself. There is no choice. And point number 3, an Indian origin who is living abroad comes on a visit to India. In such a case, he has to satisfy the first basic condition. He has no choice. However, the choice will be given in this case. If he has earned an income of more than 15 lakh during the previous year, 24-25, then he has choice of 182 days, 120 days during the previous year, plus 365 days during the 4 years preceding the relevant previous year. Okay, let me give one example. Mr. Satish, Indian origin, permanently living in USA, comes on a visit to India and earned an income of that. Okay, so assume that Mr. Satish, an Indian origin, living in USA, permanently living in USA, and comes on a visit to India, and he has earned an income of only 5 lakh in India. And in such a case, he has no choice. He has to satisfy the first basic condition itself, that is 182 days during the previous year. Is it okay? Suppose case number 2. Assume that Mr. Satish, an Indian origin, permanently living in USA, and comes on a visit to India. Further, he earned income of 20 lakh, more than 15 lakh. In such a case, he has a choice. What is the choice? 120 days during the previous year and 365 days during the 4 years preceding the relevant previous year. Is it okay? So usually what is the basic condition? Usually in all cases, people have choice, either A or B. A is 182 days during the previous year, B is 60 days during the previous year, and 365 days during 4 years preceding the relevant previous year. Is it okay? Or not? Okay. So we are aware about the basic condition. What about the additional condition? Yep, an individual must stay in India for the period of 730 days during the last 7 years preceding the relevant previous year. What is our previous year? 24-25 is previous year. And before 24-25, the year is 23-24, 22-23, 21-22, 20, 21, 19, 20, 18, 19, and 17, 18. Out of these 7 years, he must stay in India for a period of minimum of 730 days. And further, he must be resident for 2 out of last 10 years. That means 10 years preceding the relevant previous year 24-25. He must be resident. What do you mean by resident? He must stay minimum of 182 days in any 2 years out of last 10 years. Then he will be treated as ordinary resident. So we shall recollect the rule. Basic condition 182 days in previous year and 60 days in previous year plus 365 days in last 4 years. Additional condition 730 days in last 7 years and resident for 2 out of last 10 years. That is 182 plus 182. If he satisfies any one of the basic condition and both the additional condition, then he will be treated as ordinary resident. If he satisfies any one of the basic condition but fails to satisfy the additional condition, then he will be a not ordinary resident. And with regard to non-resident, an individual will be treated as non-resident when he satisfies any one of the basic condition, when he fails to satisfy any one of the basic condition itself. Okay, what will be the answer for Messi and Kohli case? Messi is a foreigner, very rarely came to India and earned the income. So will he be ordinary resident or not ordinary resident or non-resident? Here he will be non-resident because he couldn't satisfy the basic condition and additional condition. So in such a case, the income earned by Messi in India alone taxable to Indian government. The foreign income are not taxable to Indian government. With regard to Virat Kohli, he is an Indian citizen, permanently living in India, permanently playing in India. So we assume that he satisfies any one of the basic condition and both the condition. So he will be treated as ordinary resident. In such a case, Virat Kohli's Indian income as well as foreign income all will be taxable to the Indian government. He has to pay tax to Indian government for Indian income as well as foreign income. So we could summarize that ordinary resident should pay tax for all the income, whereas non-resident should pay the tax only for Indian income alone. Okay, so we shall recollect the things. Taxes based on residential status. Status is divided into three categories: OR, NOR, NR. It is based on basic condition and additional condition. When a person satisfies one basic and two additional, OR, satisfies one basic and fail in additional, NOR, fails to satisfy in basic condition, then he will be treated as NR. Thank you.